Well, if the ICC's trial against President Kenyatta had proceeded, he would have become the first current head of state to undergo prosecution there. Joining us live via Skype from Amsterdam for more perspective on today's decision is Charles Jallow, an associate professor at Florida International University College of Law. Mr. Jallow has been following this case, and we welcome him to Africa 54. Mr. Jallow, was this a surprise to you?
Well, much as your previous speaker just said, Vincent, this has been one of these inevitable pictures that we've been envisaging for the last little while, partly because of the troubles that the prosecutor has had. So in many ways, it's not a surprise at all.
Now, what does this mean to those who have been hoping that this will be perhaps a demonstration of how justice can be done at the level of the ICC?
Well, there's a complicated picture. Of course, as the previous speaker was just making mention of, State House in Nairobi is going to make a big deal of this, that the case has been dropped, and that's certainly true. But what is also interesting to observe, to add to this, is that the prosecutor, and the chamber made this very clear, always has the option to come back if they have more evidence. So in a way, the case is not really gone away yet. If they find new evidence and they can demonstrate, in their view, beyond a reasonable doubt, she's entitled to come back to the chamber and initiate the case.
Mr. Jallow, as a person who's been following this case and other cases at the ICC, the kind of evidence they were looking for, is this likely to really be availed at any time soon?
Well, the problem is it's unlikely, unfortunately, right? And the responsibility for that has to be put on the doorsteps of the government of Kenya under President Kenyatta. The chamber made very clear that even though the prosecutor should have been better prepared, the reality is that the government of Kenya has made it impossible by failing to fulfill the cooperation request from the prosecutor. So the challenge in many ways is that you have an international criminal justice system that relies on national jurisdictions, in this case Kenya, to do some of the work that the tribunal needs to do in the course of investigations. And some of the evidence, according to the prosecutor, is only available in the hands of the Kenyan government. And obviously the Kenyan government is led by Mr. Kenyatta. So there's an element almost of a conflict of interest.
In fact, some have been suggesting that perhaps what the ICC should have done is the prosecution to get those people who actually committed the acts, and perhaps then they would name who were behind this acts.
Well, that's a great suggestion. That's a great suggestion. I think that part of, if you look at the other international criminal tribunals in the past, there's this whole idea of working your way up. And this is, again, not unlike what you might get in national jurisdictions. So prosecutors start with lower-level individuals, perhaps middle-level individuals, and then ultimately they go for Mr. Big at the top, right? This is the famous conception of a mafia don sitting in the back. But you can only prosecute that person if you get insiders. So maybe the strategy of the prosecutor ought to have been to start from a lower level, maybe middle-ranking individuals, and then before you work your way to the head of state. And of course, this is what they started at the top. At the time, of course, it wasn't the president, but sufficiently senior to perhaps have escaped prosecution for a while until they got the lower-level cases. So in many ways, it's a question of prosecution strategy, and it's always hard to second-guess the prosecutor because they have evidence that we don't.
All right, Charles. We'll be watching this, and thanks a lot for being there for us today.
Okay, thank you for having me.
Well, Mr. Charles Jallow is an associate professor at Florida International University's College of Law.